All right, today we're going to answer the question, should I stay on with a law firm after I get a patent granted? I am JD Houvener, owner and founder here at Bold Patents Law Firm, also the author of Bold Ideas, The Inventor's Guide to Patents. I've helped thousands of inventors over the 10 years of my career and look forward to helping you here today. So let's unpack this question, which did get to a bit more nuance. It said, hey, I'm now at the 7.5-year mark of maintenance. So after you get a patent granted, every 7 or 7.5 years, you have to pay maintenance fees to keep the patent enforceable. This is for a utility patent. And the question says, is there any real benefit apart from the reminders? Why would I stay on with this law firm 7.5 years after the patent is granted? Do I need them? And the question is, the answer is, no, but there are huge benefits to staying on as a client. So let's go through about 5 things I came up with as a reason why you'd want to stay on with a law firm, why our clients stay with us on what we call our maintenance plan. So yeah, first and foremost, it's the reminders. We are busy. You are busy as an entrepreneur, business owner, an inventor. You got your head down, likely doing 100 different things. We are focused on helping you. And so that's one thing, first and foremost, yes, you're correct. The reminders are huge. Making sure you make the payment in the right way. That's number 2, making the payment in the right way. We know and keep up with the forms, our docketing, our paralegals are on it in terms of communications with the USPTO. We know exactly how to make that payment so it gets received, confirmed, and done in a professional way. Now, it may seem like a huge chunk of money, but a couple $100 to get the filing done correctly, it is worth it, especially if your patent is helping you be competitive in the market and you want it to make sure it lasts that other 13 to 14 more years of exclusivity. Number 3 is you stay on as a client. And that means that your attorney stays as the attorney of record at the USPTO. And so they're still ready to receive any official correspondence related to your patent. While it's rare, there are sometimes cases where the USPTO examiners or staff or even PTAB during the proceedings can send letters out, notice letters regarding patent owners during its pendency. So make sure that you have an attorney of record that's able to receive, review, and give you instructions on what to do. The law can change. And so it's great to have an attorney inform you as to whether your current patent that's issued is still valid. So seeking an opinion, talking with them about your rights. Are you going to be able to enforce this against an infringer because a certain case law or certain MPEP, the Manual Professional Examining Procedure, has changed due to a congressional legislation that's passed or to a decision that's been made in court. Last but not least, I would say the goodwill, right? Having that client-attorney relationship, maintaining that with a law firm can get you additional bonus referrals. This is more than just the yearly bonus if you get a client, gift. I'm talking about being able to sit down with an attorney in a consultation. So our firm, for example, offers a free consultation to a client that is an active client. And so if you're paying that few $100 a year to help maintain your patent and have them pay the fees, you get to have them have an open ear to about future inventions, about other issues that you're working through as a business owner, and you can get referrals to other people in that professional sphere. So I think the benefits far outweigh the minor cost in having a professional pay your maintenance fees. So hope that was helpful and insightful to think about, maybe I should keep staying on with a firm like Bold Patents after my patent gets granted. I'm JD Houvener, owner and founder here at Bold Patents Law Firm. Thanks for taking time and listening. Have a great day. Go big, go bold.